The state is always thinking of ways to push on us to infringe on rights, and we always have to stay a step ahead to push back and vindicate those rights.
It seems like what they did was, if they were going to be forced to issue people permits to carry, they were going to set out a bunch of landmines to get people jammed up and really have a chilling effect.
It's so obvious. I mean, it's like you can't even say it with a straight face. For decades and decades, you had these rules for how to get a carry permit. Now that people can actually carry, oh yeah, we're going to change that. We're going to make it much worse. It's a really, really clever but insidious, evil way of thinking about how to undermine people's fundamental constitutional rights.
Turn the lights down, and just put this on. It's right behind you.
The only garbage I see floating out there is just supporters.
Greetings, loyal ladies and gentlemen of the Garbage Gang. Welcome to another episode of Mike G and the Garbage Gang podcast. Remember, if you want to be a member of the Garbage Gang, we need you to like this video and subscribe to our channel. I have once again ventured into the People's Republic of New Jersey to sit down with a very special guest. We've got Dan Schmutter with us here today. Dan is an absolute warrior when it comes to Second Amendment litigation here in New Jersey. He's in court fighting it out against New Jersey's ridiculous, oppressive gun laws. Dan, thank you so much for joining us.
Mike, thanks for having me. I appreciate being here.
And I can tell people that you're not just a warrior in the courtroom when it comes to the Second Amendment, but you're a true believer. From time to time, I'll get a call. Hey, Mike, I'm coming to Pennsylvania. What do I need to know about carry laws out here?
Absolutely, and you're the guy to call.
So you carry on a regular basis. We even ran into a little bit of an issue when you're on your way to the studio here today, didn't we?
Yeah, well, I'm either blessed or burdened with the knowledge of how our carry laws work here. And so I'm always thinking about, where can I carry, where can't I carry? As you know, the carry killer law, as they call it, or the Bruin response law that New Jersey passed in order to further restrict New Jerseyans' ability to carry, is one of the cases we're litigating right now. And so I have an intimate knowledge of how it works, and I'm always thinking about, okay, can I carry in this place? Can I not carry in this place? Why can I? Why can't I? So yeah, we did run into that today.
And so, what is that issue? Why don't you explain that a little bit? For
Sure. So, and if you don't mind, I'll go into a little bit of the background of the law.
Sure.
And its place, in the Second Amendment struggle. So, as your listeners may know, in 2022, the Supreme Court decided New York State Rifle and Pistol Association versus Bruin. And it was a very important case for many reasons, including that it directly dealt with the right to carry. And, for many, many, many years, states like New Jersey and New York and California and Maryland, similar states like that, were notable holdouts in the trend to liberalize carry laws. Starting in 1987, when Florida passed its famous concealed carry law that allowed people who previously were not allowed to carry to get carry permits, that started an entire trend that swept the nation of states liberalizing their carry laws. But there were some clear holdouts, and New Jersey was one of them. And New Jersey steadfastly refused to come into the reality that people should be allowed to and have the right to carry handguns. So Bruin changed all of that. The Bruin decision made it clear that the Second Amendment guarantees a right to carry handguns, not simply the right to possess them in the home, but to carry them for lawful purposes outside the home. And so the decision came down in June, which is very not unusual for the Second Amendment cases, because they tend to be fairly controversial on the court, and so there are opinions going back and forth. I don't want to get too inside baseball for your listeners, but when the court deals with difficult decisions that are politically controversial, legally controversial, what happens is the justices will be writing opinions. They'll be circulating them back and forth. There will be majority opinions circulated, there will be dissents circulated, there will be concurrences, meaning justices who voted in favor of the majority but also have something else important to say about the subject matter. And that takes time. And so these kinds of cases you tend to see at the end of the term or at the end of the active term where the justices are actually issuing opinions. And that's typically June.
Wasn't it also Clarence Thomas's birthday?
Yes, I believe it was. That's actually a great fact.
Happy birthday to
Yeah,
me, Clarence
yeah.
Thomas said.
So June is when the decision came down, and the states, the anti-carry states, absolutely lost their minds. New York went first. New York they actually called a special session of the legislature back in order to pass a law responsive to the Bruin decision, because the Bruin decision was clear that it compelled these anti-states to allow ordinary law-abiding citizens to carry handguns, and they weren't going to sit for it. They were going to do whatever they could to undermine or circumvent the Supreme Court's ruling, and ultimately undermine and circumvent the United States Constitution. So New York, as I said, New York went first, and what they did was they passed a law within like a week, I think, of the decision, roughly, or two. They passed a law which did several things. It created these so-called sensitive places, the idea that, okay, well, you have a constitutional right to carry, but you can't carry in these places. And of course, if your goal is to restrict the right to carry as much as possible, you're going to create a lot of so-called sensitive places. And so, when the Supreme Court says no, ordinary citizens have a general right to carry handguns for lawful purposes under the Second Amendment, and you're in New York or later New Jersey or Maryland, Hawaii, or California, and we'll get to that if you want to talk about that, you're gonna do whatever you can to say, oh yeah, I have to issue permits. Okay, now try to use them. And that's exactly what happened. New York passed a ridiculous law called the Concealed Carry, ironically, the Concealed Carry Improvement Act. It's a great name, right? Which created these sensitive places where you can't carry, and then created what is this sort of insidious rule, what's called sort of referred to as the private property rule. And what it basically says is it sort of completely changes the general relationship that people have with property owners. And what typically a property owner determines what you can and can't do on their property. Can you enter? Can you not enter? Can you, no shirt, no shoes, no service, that kind of thing, the typical thing. And so people for hundreds and hundreds and hundreds of years thousands of years, have been completely familiar with the idea of private property, and that the property owner gets to make the rules as to what you can or can't do on their property, or even if you're even allowed in. Well, so the New York law and several of the other laws that followed totally upended that concept. What the state of New York said is you can't enter private property unless you have express permission while carrying your gun, unless you have express permission to do so. And so the state was making up the rules for the property owner, forcing the property owner to opt out of the carry scheme. Now, here's the problem, and the states understand this, which is why they passed these laws. Generally speaking, and for for your audience members who carry, they'll be familiar with this concept. And I've been all over the country, and I pay attention to this stuff because it's important. Being a person who litigates these issues in New Jersey and New York, it's very important to see how these same issues are treated in other parts of the country. People in New Jersey and New York sort of are sheltered in the sense that if they don't travel a lot, but even if they do travel a lot, they tend not to realize how the subject of firearms is dealt with in other places. And it's foreign to a lot of native New Jerseyans and New Yorkers when they hear that people outside this area have a completely different relationship with firearms. And it's kind of shocking to them that they're in the minority in terms of how they understand firearms and how people deal with firearms. So one of the things I've noticed when sort of looking at other states is that property owners, particularly business owners, generally do not want to enter the fray either way. They don't want to make these politically charged rules because they're in business. They want everybody to come into the store. It's like it's like what Michael Jordan famously said: Republicans buy sneakers also. So they generally don't want to choose between people who have one political view versus people who have another political view. So even in some of the bluest places, like for example, I used to spend a lot of time in Ohio, and what I know, and if you know Cleveland, for your folks in Ohio, Cleveland tends to be very politically stratified. On the west side of Cleveland is fairly red, the east side of Cleveland is fairly blue, and you tend to see that in voting patterns and in populations and things like that. You would expect, or at least I expected at the back then, before I had a sort of very robust experience about how carry was conducted around the country, you would have thought that you'd see lots of signs, no gun signs on the east side, and very few no gun signs on the west side. In fact, there are very few no gun signs anywhere in Cleveland and the Cleveland area. And I saw this in Pennsylvania, and I saw this in other places where I would observe, because once you are sort of sensitized to the idea of carry, you start paying attention. And you start seeing what's happening around you and how property owners and business owners look at this stuff. And the reality is, even in the bluest of blue places, you rarely see no gun signs. And the reason for that is they don't want to get involved. They don't want to enter the fray and run the risk of pissing people off. People, you want customers of every stripe. You want everybody to come in and buy your products or come to your store or engage in business. You don't generally want to isolate or reject a certain group of people. And that's typically how it works. You'd see a sign here or there. Occasionally you'd see a sign, and where you saw signs was typically where someone had a particularly strong view, and they wanted either they had a certain way of believing or understanding that was either erroneous, or it was their politics, whatever. Fine. But it was still fairly rare. Now, why am I sort of going on about that issue? The states understand that. It turns out that private property owners and private businesses are unlikely to enter the fray either way. They're unlikely to put no gun signs, but they're also unlikely to put guns welcome signs. And so all the state has to do is shift the rule from you need to explicitly prohibit guns if you want to keep guns out of your store, to you have to explicitly welcome guns, if you want people to be able to carry guns in your business. And they know that most private property owners will not bother to do that, either because they don't want to, they don't have a strong view on the subject, or because they don't want to alienate anybody. And so with that knowledge, they said to themselves, this is how we're going to prevent people from carrying and from exercising their fundamental constitutional right to carry. We're simply going to take, and we're going to call it, it's just a presumption shift. There are presumptions in the law all the time. The presumption is one way, but there's no reason why the legislature can't shift it the other way. Well, there is an important reason. There are lots of important reasons why they can't do that, but it's insidious that the strategic thinking is so insidious that they understood the general mindset of people that they're unlikely to jump in and put up a sign. So all we have to do is make them put up a sign that allows carry, and they're not going to do it. And it's a really, really clever but insidious, evil way of thinking about how to undermine people's fundamental constitutional rights. And this is the kind of thing we see all the time when we struggle to vindicate fundamental rights. The state is always thinking of ways to push on us to infringe on rights, and we always have to stay a step ahead to push back and vindicate those rights. And it's not just about the Second Amendment, although my space is the Second Amendment for the most part. I do First Amendment stuff as well and some Fifth Amendment stuff as well, but most of my stuff is Second Amendment. But this is the general struggle of the individual against the state. This is how people need to sort of protect their general rights to remain free. And this is the constant struggle in how we do this. They're constantly, because they're very smart, they're constantly coming up with ways to undermine rights, and we have to be just as smart or smarter and push harder back on them to vindicate those rights.
And you were saying that the New Jersey law requires specific permission from the building owner, not just the business.
So this is really, and I don't know whether it was intentional or not, but the New Jersey's version of the law. So as I said, New York lost their mind immediately. New Jersey waited a little bit. New Jersey kind of went to school a little bit on how New York's situation went. New York passed their law in July, like literally 2 weeks later. New Jersey waited until December, and I guess learned a little bit about New York's experience. Kind of the New Jersey law is different in important ways. It's actually worse than the New York law because New Jersey, in addition to the private property law rule, which was very, very harmful, they also created a prohibition on carry in vehicles. So basically, if we hadn't gotten the preliminary injunction that we got when we went to court on this in federal court, you would walk out of your house, get into your car, and immediately disarm. You'd get to your destination, you would rearm unless you were in a sensitive place on private property or in any of the enumerated list of sensitive places, then you disarm again. So the way they designed it is that most people could go through their entire day and not carry, and not be able to carry, because of the way they set it up. They managed to sort of slice off one slice after the next of people's ordinary lives so that they had a comprehensive ban on carry. It's unbelievable how this works. So the private property rule in New Jersey is actually worse than New York because the New York law says that if you want to carry on private property, you need express consent from, I don't remember the exact language, but it's essentially the owner or tenant or other person in possession of the property. And, for people who understand real estate or either real estate law or just how real estate works, you have owners, you have tenants, people are in possession. And, when you're a tenant at a property, you control access, you control most aspects of how that property works and how it's operated. The New Jersey law says you need express consent from the property owner. That's it. Now, as you know, Mike, so much business property, so much commercial property is owned by these large REITs. How are you going to figure out who the actual owner of a mall is, or of a strip mall, or of a center, or of an office building? You're going to contact, some massive REIT to figure out who's the land. No, of course not. So you can't even go. So you may have the most Second Amendment friendly business in that property. As a matter of law, he can't give consent because it has to be the owner, which is another serious flaw in the statute among the other flaws that we've identified in the litigation that we're currently involved in. So this is the goal. This is the fight for individual liberty. It is dealing with these kinds of very, very clever but evil ways in which the state can undermine your rights.
It seems like what they did was, if they were going to be forced to issue people permits to carry, as you call them here, they were going to set out a bunch of landmines to get people jammed up and really have a chilling effect. You talked about litigating First Amendment issues. This is a chilling effect on people exercising their Second Amendment rights because they hear all these different things and they say, I don't even want to take that risk.
Correct.
If Dan's having trouble parsing out from time to time whether the facts meet the particular law that prohibits somebody, I'm not going to deal with that and get myself into trouble. So you probably have a lot of people who shy away from carrying as a result.
And they count on that as well, right? And New Jersey's always worked that way for many, many, many years. The New Jersey gun law, I'm sure, I don't know, you may have spoken to this about this with Evan Knappen when you had him on. Great show, by the way. That was a great show.
Thank you.
But Evan always talks about how New Jersey gun law is designed to put the fear in people that they are at risk all the time. Because presumptions work against you typically, even though there are certain aspects of criminal law where you're supposed to get the benefit of certain things. Nevertheless, they design New Jersey gun law as much as possible to work against you in terms of presumptions and to work against you in any way possible. So the law-abiding New Jersey firearms owner is made to feel like they're constantly at risk. And they do that on purpose because of the exact deterrence effect that you referred to. It is designed to put people in fear and to discourage them from exercising their fundamental rights. It's really awful.
Yeah, the case law says the Pelletieri case, he deals guns at your peril, right?
Exactly.
So
Yeah,
I want
that's going to go away.
I would love it. Another thing that I want to go back to is you spoke about how people from New York and New Jersey are somewhat naive to the relationship people have with firearms in other parts of the country. When I had Evan on, he talked about how he grew up a gun guy here in New Jersey. Me personally, I was born and raised in Brooklyn, where I didn't know a single law-abiding gun owner, legal gun owner, till I got out to college in Oklahoma. You're from New York as well, aren't you?
Yeah, I grew up like you. I grew up in the Bronx. And to me, I didn't grow up around guns. To me, guns were on TV. You know, criminals had guns, cops had guns, criminals had guns, soldiers had guns. That was it, right? That's how that worked. And so if you weren't a soldier or if you weren't a police officer, you were a bad guy. You know, I had, and it's, you know, as you know, the media do that with intention, right? There's politics involved in stories that we see in film and in TV and things like that. And so we grow up. If that's your only experience with firearms, that's what you grow up and that's what you're taught. And so, you know, my first real experience with firearms was in law school at the University of Virginia. You know, and that's really quite a not just a physical but cultural distance from my upbringing in the Bronx. You know, I grew up in a very blue household, and it was real culture shock. And that's where I first learned to shoot, and that's how I sort of started to really appreciate the right to keep and bear arms and the Second Amendment and firearms generally. So when you come up with when you come up with, you know, when you grow up in that kind of background, you really don't understand how the rest of the country understands these things. I'll tell you just a funny story. Years ago, I was vacationing in Arizona, and it must have been a 7-Eleven or some convenience store, and I'm standing in line to buy something, and the guy in front of me has a 1911 open carry on his hip, and you know, I'm like, well, that's interesting. And I was already a gun guy by then. I was already a Second Amendment guy. This is not when I was, you know, still living in the Bronx. This is later in life when I was already fully into the movement. It still was kind of shocking to me, you know, because I'd never seen that before. And this is someone who had become sympathetic and very involved in the Second Amendment movement. It still viscerally affected me. And it's like, oh, wow, look at that. Guy's carrying a 1911 on his belt openly in 7-Eleven buying like a Coke, you know. Since then, of course, you know, that was years ago. So since then, of course, you know, living this lifestyle, it's much less of a visceral type of reaction. But, you know, it's very hard to undo the things you've grown up with. You know, you're inculcated into these things as an upbringing. And it still affects you even years later, you know. But I thought it was very funny. That is a great example of the cultural difference between a guy who grew up in the Bronx and, you know, being at a convenience store in Phoenix, you know.
You know, you bring memories back to me because first time I saw somebody open carry was at Pep Boys in Arizona. I was out there playing ball for the summer, and I had been exposed to firearms previously in undergrad in Oklahoma, but Oklahoma at the time prohibited open carry. It wasn't until 2012 where they passed a law where if you had a license to carry, you could also open carry. And interestingly, tying into what you were saying about business owners, when Oklahoma passed open carry, there was a grocery store across the street from a Walmart. And this grocery store is known as being the Cadillac of grocery stores out there. If you want a pleasant luxury experience, that's where you go. They put out a statement saying, we respect the Second Amendment, but we prefer you not open carry in our establishment. I believe it was that afternoon, Walmart issues a press release, their store being across the street, saying, you want to open carry? Come on over to Walmart. The following day, the original grocery store says, we were just kidding. We don't know what got into us. Of course, you can open carry here, but just an example of how you can alienate your customer base.
Capitalism for the win. There you go.
People don't want to deal with that.
Absolutely.
So let's get into some of the cases that you've got going on right now, because there are quite a few of them. And I think it would be natural for us to begin with the carry killer case, right? So let's talk a little bit about that.
Sure. So as I said, New Jersey passed their carry killer law, and carry just for your audience, there are a number of ways people refer to these laws. Sometimes they're called carry killer. Sometimes they're called Bruin response laws because they are literally a direct response to the Bruin decision. But anyway, we're talking about the laws that a number of states, in particular New York, New Jersey, Maryland, Hawaii, and California, have passed in order to undermine and circumvent the Bruin decision. And even though there is a fundamental individual right to carry a handgun outside the home, these states have nevertheless decided that they're not going to accept that, and they're going to do everything possible to undermine it and prevent the exercise of that right. So that's what we mean when we say carry killer or Bruin response law. Okay. So New Jersey passed their law in December of that year, and I represent the Association of New Jersey Rifle and Pistol Clubs on a lot of these cases, and JRPC. It's referred to typically as an abbreviation. And we knew this was coming because it was in the legislature, and of course we follow as an organization legislative efforts, and we know what's in the what bills are in the legislature, and we sort of kind of try to follow which ones are likely to pass, which ones are likely to not pass, which ones have the strong support. The carry killer bill, this was because, after Bruin was decided, Governor Murphy did a press conference immediately talking about how terrible he thought the decision was, and, how he has to protect New Jerseyans from the Supreme Court, nonsense like that. So we knew immediately that he was out to undermine Bruin and push back in whatever ways he thought he could. So we knew this was coming. And when the bill there's actually more than one bill that was introduced into the legislature over the summer, but we knew it was moving. We saw it was, so we knew it was going to pass. It was pretty clear that this was a top priority for the state of Jersey. So it wasn't one of these sort of random bills that some senator or assembly person threw in, filed with the legislature. This was a priority for them. It was obvious. So we were following it very closely. And so on the day that, so it passed, and on the day that Governor Murphy intended to sign it, he did this whole dog and pony show at a library. Because a library is one of the prohibited places. So he had the Attorney General, he had the President of the Senate and the Speaker of the Assembly, and so he had all the different legislative leaders all there, and various political operatives ready to give speeches. Never gave their speeches, so we knew when he was going to sign it. So we were ready. So we had prepared our complaint. I was literally sitting in front of the computer, ready to electronically file the complaint the moment he put pen to paper. And it's funny, for your audience members who are lawyers that file papers in federal court, they know how you go about that. You log in, you create the case, you identify the parties, and then once you create the case on the computer and you're sitting there typing in the names of the plaintiffs and the defendants and the whole things, you get your case number, and then it asks you the question, file initial pleading or file your initial opening paper. So that's really what gets the case going, because you can open the case, you can get a docket number, the computer can be waiting for you, but until you actually file your complaint, you don't have a case going. So, of course, I'm sitting there in front of the computer, I'm watching, I have a window open watching the live stream of him, everybody giving their speeches, and he's got a table with like pens and he's like the whole thing. And I'm sitting there with my finger and I'm like, okay, getting ready to hit enter to file the complaint, And so I'm staring and I'm like, with like this, and he picks up the pen and it's like, okay, like this was like, file,
Right away.
And what's funny is we weren't the only ones doing that. So there are actually two cases that have been consolidated for procedural purposes. So our case is called Siegel versus Platkin, and that's ANJRPC and NRA. And then there's a case called Coons versus Platkin, and that's the Firearms Policy Coalition, FPC. I'm sure your audience is familiar with them. And we literally filed like within seconds of each other. We're both watching, we're both sitting there ready to hit the enter button to file the cases. And we have consecutive docket numbers. And this is actually, I'll tell you this story because this is one of my favorite parts of the case. So we filed simultaneously within seconds or maybe even a minute of each other. We got consecutive docket numbers. If I recall correctly, I think our docket number is lower. No, maybe their docket numbers. I forget which one it is, but they got in front of, we had two different judges. They got in front of their judge before we did on a temporary restraining order. So, for your audience members who are not familiar with the procedure, you can get emergency relief from a court if things are happening that need to be addressed before the case can be tried. As you know, as a lawyer, it can take years to get the case to trial, and so it can take a long time before you get the relief that you're asking for. And if there's irreparable harm, as we call it, as you know, that is harm that cannot be compensated with money damages, you can ask the court to give you an injunction, a temporary injunction now, during the pendency of the case. So a TRO is a temporary restraining order. A TRO, as you know, is an emergency, like we need relief now. We need relief today or next week. And then the judge can decide, okay, well, they give you that temporary restraining order, and that should last typically a few weeks, and then you go and ask for what's called a preliminary injunction, as you know. And that is similar, but that's designed to last for the whole case. And then finally, when you get to trial, you've been protected from this irreparable harm for the couple of years it might take before you can get to trial. And the idea is, while it take, these couple of years it's taking me to get to trial and to get final relief from the judge, all kinds of terrible things are happening. And I'm exposed for these couple of years. So that's what a TRO and a preliminary injunction do, as you know. So we both filed applications for a TRO. They got on the calendar in front of their judge, I think about 4 or 5 days before us. I think they got into court like on a Friday, I think, and we weren't going to be in court until Monday or Tuesday, something like that. I think it was. It might have been a Monday, or they were in court on the Thursday, and we were scheduled with our judge on a Monday. So they argue their case on the Thursday. Arguments seem to go, reasonably well. I mean, it's long since I stopped trying to predict what judges are going to do. Judges are human beings. It's really difficult to know what a judge is going to do. It's you think you know how the judge is thinking about something, and you can glean you can try to sort of figure out, well, what seems important to this judge, and you can base that on the questions at oral argument that you get at oral argument. But to try to actually predict what the judge is going to do, I stopped doing that a long time ago. You can't. But the arguments the questions being asked seemed like the right questions, right? If a judge is thinking clearly about a topic in a way that you think is important for the judge to understand the subject matter, you can often tell that from the questions that are being asked. If the judge asks a certain series of questions, you can say to yourself, I see. She understands the significance of that issue. Doesn't tell you whether she's going to come out your way on that issue, but she understands it because of the nature of the questions she's asking. And that can be very helpful in sort of at least, because look, as lawyers, you understand this. The best you can do is position yourself to get a fair hearing in front of a judge, right? You can't make the judge do what you want. But what you can do is you can arm the judge with information, factual and legal, sufficient for the judge to rule your way, right, if they agree with you. And then all you can hope for is fairness, that you get a fair shot in front of a judge. And after that, whatever happens, happens. So hearing the argument, I was thinking to myself, this seems like the judge seems to be thinking soundly and clearly about the subject matter, which is, again, something that you really look for. Because sometimes you go in front of a court and it's like, this judge has no understanding of what's happening. And look, in fairness, our job as lawyers is to educate the judge on the subject matter. A lot of lay people don't realize this. Judges are generally not specialists. I mean, there are certain areas of law where you have, like bankruptcy law, for example. That's a specialty that there are bankruptcy judges who do nothing but bankruptcy all day, every day. But usually, for most purposes, judges are generalists. And so you shouldn't expect them to know about your topic. And that's the lawyer's job, to educate the judge on the topic, both factually and legally. And a lot of people don't understand that because they don't realize they say, well, how come the judge does, why can't we have a judge that knows this stuff? Well, you might get a judge that knows that stuff sort of, randomly. But actually, judges really aren't supposed to decide cases on their individual experience. I mean, obviously, judges have lives. They have their background, and so they understand the world based upon their experience. But really, judges are supposed to decide cases based on the record in front of them, and the record is created by the lawyers. There are facts that you present to a court. There's law that you present to a court, and that's really how judges are supposed to decide things. So the idea that judges are generalists, they're not tabula rasa, as they say, right? They're not a blank slate. So of course they bring their own life experience to things, and of course a judge who is familiar with firearms is going to understand the issues much more easily than a judge who is unfamiliar with firearms. I'll tell you right now, in our magazine and so-called, assault firearm case, the district judge openly said at oral argument in connection with our summary judgment motions, I don't really know anything about guns. And we knew that because our magazine case dates back to 2018. So we had been familiar with this judge for a number of years. So we kind of understood, based on the kinds of questions that he asked and some of his rulings, we kind of figured he's not a gun guy. He doesn't really know this stuff. And again, as lawyers, that's our job, is to educate the judge on the topic and to educate the judge on the law, because that's what a judge is supposed to do. They're supposed to take the record that's presented to them and use that to understand what's going on, what the issues, what the factual and legal issues are, and develop a ruling that's appropriate as they understand the record. So having sat through the TRO oral argument in the other case, I came away with the impression that the judge seemed to understand the issues reasonably well. The judge clearly had done her homework. The judge had clearly read the papers, had read the cases, seemed to understand them well, and was asking intelligent, meaningful questions to really drill down into the details of the issues, because when you file a brief, as you know, you can only say so much in a written document for two reasons. There are often page limits or word limits, as you know, but also you can't present a judge with a giant brief that, these are people. You have to say things concisely. People tell when you're a young lawyer, you think to yourself, well, I want a larger page limits because I want to be able to say 100 different things. And then as you get more experience as a lawyer, you realize that's a mistake. You actually want fewer pages, fewer words, because you need to convey the message concisely before the judge's eyes glaze over, from some gigantic document that they're not going to read. You present the judge with a 300-page brief, they're not going to read 300 pages. They're just not. They're busy, and they have a lot of cases. Your case is not the only case they have. So you've got to say it quickly and concisely, that kind of thing. So it seemed like a reasonable hearing. Again, I don't predict these things anymore. I didn't go back and call my client and say, oh my God, this was amazing. They're going to win. You can't do that. But it was our turn on Monday. So we had a different judge. So we get to court on Monday, and this is in Camden, New Jersey, the federal court in Camden. And I park my car, and I'm walking from the parking lot to the courthouse, and a buddy of mine texts me and says, oh, did you see the ruling? I said, what ruling? I'm like literally driving, and I'm parking, and he says, oh, shit, ruling. And so, of course, I'm sitting there on my phone. Oh, my God, what's the ruling? What's the ruling? And the judge in the other case had granted the temporary restraining order with I think it was a 60-page opinion, Now, that's a pretty hardworking judge, right? I mean, the hearing was Thursday. On Monday, she comes out with, I think, what was a 60-page opinion. And that's what you want from a judge, right? I mean, you want that level of dedication and energy, knowing, because a TRO is very important, right? If you've presented a record to a judge that says, Judge, there is an emergency taking place right now, we need relief right now, then you hope the judge will take it seriously enough to say, okay, we're going to roll up our sleeves, we're going to dig into this over the weekend, I'm going to have my law clerks here with me, and we're going to bust out an opinion of some sort, right? So that's great. I mean, you when you see a judge with that kind of dedication to what they're doing, it's very gratifying, because there are lots of judges out there that don't do that. But you hope that most judges you appear in front of will have that level of energy. And it's great. And it was a very favorable opinion in many respects. It wasn't perfect, but it was really good. So now I'm going through. So I'm reading this thing literally as I'm walking, and I'm going through security through the metal detectors, and I'm pulling all the crazy stuff out of my pockets because I keep ridiculous things in my pockets. So at courthouses and airports, I hold up the line. It drives people insane. I'm throwing all kinds of things in the bins. And it's like, what's this stuff? And where did you have this in your pockets? So I get through security, and I'm literally putting things back in my pockets on the other side of the metal detector, and the lawyer in the other case walks through the front door. So I call over to him. It's like, oh, congratulations. He goes, for what? I said, you got your TRO. He said, I did? It's like, it literally just happened. So of course we get into court, and of course our judge had been informed about what happened, so she knew that the other judge had ruled, and so of course it required that the judge basically said to us, look, I need you to brief, meaning, as you know, when you brief something, you're writing arguments, you're providing written arguments to the court. I need you to brief the significance of the other judge's ruling. I need you to tell me what you think that means for this case, and that's appropriate, right? Because obviously, as the plaintiffs in our case, we think that the judge should follow that ruling and do the same thing because we're asking for the same stuff. The state may have a reason why they think the court should not follow that judge's ruling. The court judge didn't have to follow what the other judge did. Obviously, our position is, no, you should do what the other judge did. She was right. You should do the same thing. Yay, right? And the state, of course, would be arguing, no, she was wrong. You should, do something different because she was wrong, and you should do it the right way, the way we say. Okay. So we had to come back and write and brief that point. The state had also filed a motion to consolidate the two cases. Now, of course, the reason the state wants to consolidate the cases is because they don't want to have to litigate on multiple fronts. It's more efficient for them to be able to handle something in one forum. So they're saying, oh, Judge, we shouldn't have to litigate these separate cases. But there are also important reasons why you may not want the cases to be litigated together. You may have a certain way of thinking about an issue that the other plaintiffs don't. You may want to present it in a certain way, and you may not want their arguments in your record. I mean, who knows? This is sort of just generically speaking about procedure, but there are lots of reasons why you may not want the cases to be consolidated. Okay, well, the way the practice had traditionally worked in New Jersey, at least this is, I'm doing this more than 30 years, and this is how I've always seen it. The way the rule works is that the judge that has the earlier case is the one who decides the consolidation motion. And so what happens is you make that motion to the first judge. And the first judge gets to decide, yes, we're going to consolidate these cases. No, we're not. Okay. Now, our judge, since we had the lower docket number, they made the motion to our judge. So one of the things when we showed up on that Monday that was at issue was not simply what does this TRO mean for our case that the other judge issued, but also tell me about consolidation and how does this affect consolidation? Well, the general understanding about consolidation that practitioners were living under was, well, because the earlier judge is the one who decides the motion, the consolidation goes into that case. That's how people kind of thought about consolidation. Now, there's no rule on that. There's no case law on that. That's just kind of how it worked. And so what the state was saying was you should take the case away from the other judge, bring it over here to the judge who had not yet ruled. And so I'm sure they were thinking, well, we lost in front of this other judge, this first judge. Wouldn't it be great if we got the case away from her? Because we now know how she thinks about these issues. She put it on paper in a 60-page opinion. Let's see, wouldn't it be great if we could get the case away from her? So we said, well, just because the earlier judge is the judge that the rule says who decides the consolidation motion, that doesn't mean the case gets consolidated into her case. So we took the position that because the other judge has already done all the hard work, 60 pages worth, if you're going to consolidate it, it should be consolidated over there. Like, you're going to just have to repeat all of that work. You're going to have to rehash all the same issues. This judge has already done all that hard work over the course of 5 days, and writing a 60-page opinion, why would you duplicate that? If one of the key values of consolidation is to save resources, judicial resources, litigation resources, money, things like that, well, then clearly, if you're going to consolidate, it should go that way. The state lost their mind. They said, what do you mean? That's not how this works. It always goes to the earlier judge. How can you argue that it should go to the later judge? The problem is that, first of all, there was no rule against it.
Right.
And it was so compelling. It was so obvious that the first judge, having done all of the work already and having rendered a huge opinion, of course it should go to her. It would make no sense to take the case away from a judge that had already put in all that time and effort and rendered an opinion, take it away from her and give it to a judge who hasn't even started thinking about it yet. That clearly made no sense, but the state went nuts. And of course, you can predict what happened. Our judge said, yep, I'm going to consolidate, and yep, I'm going to send it over to the other judge. And that's what happened. And so that's why our case, so the other case is called Coons. Our case is called Siegel. The consolidated caption, the lead case is Coons, because that was their case. So we got consolidated into them, and we were now all in front of that judge who had already kind of gone through a very rigorous analysis of the Second Amendment issues, the factual issues, and things like that. So I thought that's sort of an example of, I thought that was fun to advance an unusual argument and win on the procedural issue that seemed to really frustrate the state, because like anyone, the state is going to use whatever procedural advantage they think they may be entitled to. If the rules work a certain way, then the rules work a certain way, and so why wouldn't they take advantage of those rules to the extent they think they help them? Turns out it backfired. They actually took two separate cases, one of which in front of one judge, one of which in front of another judge, and initially you have no idea how the judge thinks about the issue, but then once they knew how one judge viewed the case, by consolidating them, they ended up taking the case away from the unknown judge and bringing it over to the judge that they already knew had an unfavorable view from their perspective. So it backfired.
It would seem, though, that if your judge were inclined to rule against you on the TRO, that might be their opportunity to take the case on consolidation. And if they were maybe undecided or neutral or agreed with that original judge, that's when they would make the decision to send it over. Is that fair to say? So
You're talking about the second judge.
Your judge,
yeah.
Right? So if your judge were inclined to rule against you, then perhaps they would have
brought it over to her.
to her.
So it's an interesting perspective, right? Because people, again, I say this to clients, I say this to audiences when I speak, either on media or in live. Judges are humans. They're people. They have training that is atypical of the general population. They have experience with the courts and the judiciary that is atypical with respect to the general population, but they're still people. And they're affected by the things that people are affected by. So people tend to like to attribute ill motives to judges. Anytime a judge rules in a way that people don't like, there is this tendency to want to feel like, oh, that judge is just a tool, a hack, whatever. It's very, very often not true, right? I mean, there are judges out there that have a political bent, and there are certainly judges out there that have very clear views on things from a political perspective, and you can tell in the way they write or the way they speak or the way they rule, things like that. But I think people tend to overstate how many judges are like that. They're out there, but just because a judge rules against you, or just because a judge either doesn't understand your issue the way you understand it, or doesn't see it your way, it doesn't mean they're out to get you. And so when you're as a lawyer, as you know, when you're evaluating the judge you're in front of, you got to remember all the different factors that go into how a judge does her job. And you're not like we said, you're not her only case. And so, yes, I could see a judge, I'm not saying this judge, I could see a judge acting strategically in that way, saying, I don't agree with these people. I've looked at the papers, I've looked at the issue, I don't agree with these people, so I'm not going to send it over there because I disagree with that judge. I'm going to keep it so that I can rule differently, right? You can imagine a judge doing that, but hopefully most judges don't think about it strategically that way. So there are certainly some judges who do. There's no question. You and I have probably been before such judges over the years. But for the most part, the hope is, and I'm fairly sure I'm right about this, that most judges are not thinking that way. Most judges are thinking in terms of what's their caseload, what makes the most sense, how are the parties going to deal with this? Because, as you know, judges are very pragmatic when it comes to their dockets, when it comes to the administration of their cases. They have so much on their plate. It's like, well, this judge has already done all the hard work. I have 900 cases that I have to deal with. I'm just making up that number, but I have other cases to deal with. Why would I go out of my way to keep a case that another judge has already done enormous work on? It doesn't make sense for me to deliberately keep this. I'm going to send it over there, right? That's generally how you would hope judges are thinking pragmatically. And I think it's likely that is how judges are typically thinking about these kinds of things. Again, yes, of course, there are some bad judges out there that think strategically and the wrong way. But I think most judges are trying to do their job in a way that seems fair and efficient, to the extent that they're human beings who have human characteristics.
And to be clear, I'm not saying that the judge had any ulterior motives or anything like that, but it does sound like your procedural decision was one that could have gone either way.
Sure, absolutely.
And there at least was a tradition that that judge would be the one to take that case, regardless of whether the opinion was already drafted and everything like that.
Right.
And really what I gather from that is that the state was sort of spinning their wheels, because if that judge did want to rule in their favor, they may have taken that case. But the fact that they sent it over, they probably weren't going to win on that issue anyway.
Yeah, that makes sense. That makes sense.
So what are some of the laws that ultimately got suspended with this decision?
Okay, so as I mentioned, there's the TRO phase, which is only intended to last a short period of time. And then you go to the next phase, which is called the preliminary injunction, as you know. And your audience may be familiar with that process. So the TRO takes you from the beginning of the case, sort of as a hair on fire type of emergency situation, to maybe a week or so into the case until you have time to brief and argue the issue, sort of like ladies and gentlemen, sort of in a more orderly fashion. Because as you know, when you're going into court on a TRO, it's literally kind of like a hair on fire type of situation. It's a dire emergency. You're running into court. You're screaming, "Oh my God, Judge, we need relief now!" And in those situations, can be difficult for the court to really wrestle with the issues in the way that you'd like, because it is such a dire emergency. Now, I will say that the 60-page opinion that the Coons people got over the weekend was extraordinarily well-reasoned and really well-written. It just shows you what you can do when you really put your mind to it, what humans are capable of. But it's nevertheless still the case. So the next phase was the preliminary injunction phase. So we're in court on the TROs in January, let's say. Right, cases got filed at the end of December. I think December 22nd is when they got filed. So first week or two of January, we were in there on the TROs. Then now it's the preliminary injunction phase. And so now their case, the Coons case and the Siegel case, are different in important ways. Our case is much broader. So we attacked the New Jersey law, as I said, is actually worse than the New York law. So the New Jersey law has a list of sensitive places. It has the private property rule. It has the vehicle rule. It also has an liability insurance requirement, which is unique to the New Jersey law. It mandated that you have a certain amount of coverage of liability insurance, or you can't lawfully carry. It also created a whole new series of substantive requirements to obtain a permit and procedural requirements to obtain a permit. So for decades and decades, the carry permit law had a certain procedure, which the state of New Jersey was perfectly fine with. Suddenly, when regular people can get a permit, magically, oh, no. We have to have all these additional procedures. We have to change the substantive rule associated with the standard by which you can get a permit. Now you have to have more references. I think they went to 4 instead of 3, I think it was. Oh, yes, and by the way, we're raising the fees. So it's the pretextual nature of it. It's so obvious. I mean, it's like you can't even say it with a straight face. For decades and decades, you have these rules for how to get a carrier permit. Now that people can actually carry, oh yeah, we're going to change that. We're going to make it much worse. it's hard to even say with a straight face that this is obviously intended to suppress the fundamental right to keep and bear arms. I mean, like, anyway, welcome to New Jersey, right? So our case was broadly targeted towards each of those provisions. The Coons case was narrowly focused on a handful of the sensitive places, and there are valid strategic and tactical reasons why you would do one or the other. There are reasons to keep a case narrow. There are reasons to make a case broad. Interestingly, and actually it turns out to have been a good thing, that the two cases were different in that important way. When the Coons folks got their TRO, we then, of course, our TRO was teed up in front of their judge, because it was now our judge. We had already asked for more sensitive places, plus the vehicle rule, plus the private property rule, plus the insurance rule, because those were all things that urgently prevented people from carrying immediately. Those were all things that would stop people in their tracks. And so we decided that as a matter of sort of temporary injunctive relief or preliminary injunctive relief, we needed to attack those right away. So what turned out nice is that the judge took the Coons ruling and basically expanded it for us and gave us the same type of ruling, but with broader relief. So not only, and we also had more sensitive places that we were attacking. So we got more sensitive places on our TRO. We got the insurance rule was not, I'm sorry, we didn't bring, the insurance rule was not a TRO, not part of the TRO, and the fees and things like that. But so then on the preliminary injunction, it got broader. And so on the preliminary injunction, we got even more relief from the preliminary injunction. So for example, we got entertainment facilities, we got parks and recreational facilities, beaches, things like that. We got libraries, we got museums. We got, there's a bizarre portion of the statute that says you can't carry in filming locations. Now, New Jersey happens to be a very popular place for making movies. There are on-location filming things all over the place, all over New Jersey. You can't carry in a filming location under the statute. It was ridiculous. So we attacked that. We attacked a number of these sensitive places. We got most of them in our preliminary injunction, which was nice. We didn't get everything. The ruling wasn't perfect, but it was very good. We got really broad relief. We got the private property rule as far as an injunction. We got the vehicle rule. And here's something that I really like. So one of the things we noticed about this law, and again, we talked about how New Jersey likes to draft their laws really vague to create uncertainty in the individual as to like what actually falls within the law. And as you know, that's unconstitutional. You can't. Vagueness is a due process issue that impacts people's ability to exercise their rights. You know, under the due process clause of the 14th Amendment, you have to have notice of what the prohibited conduct is. There has to be enough notice in the law that a person can conform their behavior to comply with that law. You know, but New Jersey likes to skirt the edge of that and create these laws that are just vague enough that they put this serious question in people's minds as to whether it's lawful or not. And as Evan likes to say, he's right about this. Every weapons law in New Jersey is a felony level offense. You know, in most states, a lot of this stuff is misdemeanors or this. You get a fine. Every weapons offense in New Jersey is a felony level offense, and so if you make a mistake as to it's not just guns, knives, any other weapons. If there's a restriction, you run the risk of a felony conviction. And that's really serious. And so it puts this fear into people's minds. It's like, what if I get this wrong? It's a huge problem. And so there's an aspect of the New Jersey law that I like to call the multi-use property problem. And this is how we briefed it, and this is how we argued it. And there are sort of three sort of scenarios where this comes up. Because the way the New Jersey law is drafted is that the restriction applies to the entire premises, parking lots, walkways, whatever. Right? It's on its face, it ostensibly applies to everything. So what happens? So it comes up in three different places: strip malls, office buildings, professional buildings, and places like churches. So the professional building is a great example. So the prohibition included medical offices, right? But not law offices, not accounting offices, not banks, right? But medical offices. Well, as you know, professional buildings are typically mixed-use buildings. So you've got a law office on the first floor. You've got an accounting office on the second floor. You've got a real estate office on the third floor. And maybe you have a dentist in the back, on the basement. Well, a literal reading of the statute, that entire building is off limits just because the dentist has an office in the basement. It applies to the entire property. Well, we argued you can't do that. You can't restrict the law office. There is no law office provision. There's no constitutional principle that would allow, even if restricting carrying a medical office was valid, which it's not, and pretty clearly not based on the constitutional rules. But even if you thought a medical office was a proper place to restrict carry, you're restricting carry in every other place in that building, the accounting office, the real estate office, the law office. You can't justify any of that stuff. Second example, as I said, is the strip mall, right? So you've got a strip mall, you've got a pizza place, you've got a Wendy's, you've got a tailor, and then you have a daycare center on one end of the property. That daycare center renders the entire property off limits. Even if the pizza place owner and the property owner explicitly says you may carry on this property, if we're talking about the private property rule, the daycare center renders the entire place off limits if you literally read the statute the way it was written. Okay. Third example is, let's say, a church, right? So there's no prohibition on houses of worship, unlike in New York. So New York has a house of worship prohibition. New Jersey does not. But if you have a day school in the basement, right? Well, that's a school. Schools are prohibited. If schools are prohibited, the whole property is prohibited. One of our plaintiffs owns a church property that's 18 acres. And so you've got the church building. They actually have a building on the property that's a school. Well, that means that because the school is prohibited, the church is prohibited. Every acre on the 18 is prohibited simply because of the school prohibitions. Again, multi-use property. Well, we made this argument, and the state conceded, sort of the way they parsed the language of the statute, they conceded that for multi-use properties, the prohibition of one section of the property does not extend to common areas or other uses, which I thought was a very important victory, because you can imagine the vast swath of properties that would be off limits merely because of a tiny prohibited use in one corner of the property. That was a major concession that we were able to get from the state, that it does not extend out on multiple uses. So if it's a single-use property, the entire property is off limits. But if it's a multi-use property, it does not extend out to other things. That was a very important aspect of our case. That wasn't part of the Coons case, but that was part of our case, Siegel, where I think that was a very, very helpful result. So that's a good example, I think. That's a good example, by the way, of where it's actually can be very helpful to have multiple theories and multiple ways in which an issue is arguing. The Coons case has a certain focus. Our Siegel case has a certain focus. And in the aggregate, you can often benefit from the sort of percolation of theories and percolation of requests for relief. You can, the sum of the two can be greater, than the individual things that are being requested. So it's an interesting way of thinking about this kind of litigation.
Strip malls are interesting. And when you look at federal law regarding the post offices, this is under the sole control of the post office, which are always the issue where you've got grocery store, dry cleaners, and post office, and the entire parking lot becomes off limits as a result. So by having under the sole control of the post office, it's distinguishable from what you're talking about. And it also blows my mind, the house of worship thing, particularly when we've seen situations like Jack Wilson in recent years in Texas, where somebody came in blasting people in the church and a good guy with a gun happened to be there and saved the day. And so what New York is telling you is you're not entitled to be able to survive by being able to carry to protect yourself and your loved ones.
Right. And as we know, and it's not simply obvious to us, right? For those of us who understand how self-defense works, who understand how violent crime works, it's also borne out by the data. I mean, you start with someone like John Lott, who has spent his life studying this stuff, but there are many other researchers that have followed in his work who have demonstrated time after time after time that the places where these violent crimes take place are almost always so-called gun-free zones. In Aurora, we know that the shooter left us a writings about his analysis and plans and reasoning. I mean, it's astonishing. It's a horrible type of event But we actually had the opportunity to learn an awful lot about the mindset of these crazy people who have this idea that they want to go out and commit mass murder. And what we learned from the writings is the thought process that he literally thought about where he could do the most damage. And he eliminated certain places because there were too many people with guns. I think he was thinking of airports as a possible place to do it, but too many cops there. And what we learned is that he actually skipped over several movie theaters and went out of his way to go to the Cinemark because they prohibited guns. And that is incredibly illustrative of the mindset of how criminals work. One of the things that we've known for many years is that one of the things that criminals fear most is getting shot by private citizens. They fear getting shot by private citizens more than they fear police, because police have certain rules of engagement that individuals don't have. Individuals are governed by the law of self-defense. Police officers are governed by other kinds of rules, and so they're not worried about getting shot by police. They are worried about getting shot by private citizens. And so this idea that somehow you're going to stop or prevent or deter violent crime with a rule or a sign is ludicrous. What you're actually doing with a no gun sign is you're creating a magnet for violent crime. You're announcing to the world, no one here is capable of defending. Everyone here is defenseless. We're telling you this. Everyone here is defenseless because we prohibit guns. And so you're inviting crazy people to come and commit mass murder. It's the most ridiculous thing you can imagine, but it's incredible. And this is really the cultural difference. It is extraordinary how many people don't understand that thinking. And it's not because they're stupid. It's not because they're evil. It's they're not exposed to the way of thinking, to the understanding of how crime works, how it goes down, how defense works, they're just not exposed to that. So they just assume, well, of course we want to prohibit guns there because we don't want people to get shot. They don't understand. And, look, intelligent people can be educated on things. And so when you explain it to open-minded people, because as we know, there are plenty of people out there who are not open-minded, but for honest, sort of thoughtful, open-minded people, when you show them the flawed reasoning behind a no-gun sign, it gives them something to think about. It's like, you know what, I didn't actually never thought about it that way. To me, oh yeah, guns bad, no guns. We don't want people to get shot, so no guns, right? Isn't that how it works? And like I said, honest people who are open-minded, you can explain this to them, and they look at it and they say, yeah, it's really actually I never really thought about it that way. Here's a great example. New York City, in Manhattan, the guy who walked into the office building with an AR. People are automatically thinking, oh yeah, we need to prohibit guns in that building. It's like, the guy walked right past security, he shot the guy, and then he got in the elevator and started shooting people. How is a prohibition on firearms in that building going to stop that guy? He literally walked across the plaza with an AR in his hand and started shooting people.
He would have turned around. He would have got there and be like, I guess these are not allowed in here.
There are no guns in this
I
building?
want to kill all these people in this building, but I can't bring a gun in here because that would be against the law. Dan, I got to apologize that I'm biting my lip trying not to laugh while we're having this conversation. And the reason is, you're talking about the home situation out in Colorado and John Lott, all the research that he did. When I was in law school, John Lott came to our school and with the Federalist Society gave us a speech about a lot of his research. And one of the things he talked about was that situation in Colorado. And I believe he said that he passed over on 5 theaters that were actually closer because this is the one with the no gun signs. And you were saying how not everybody who's uneducated to this or thinks that way is an idiot. But guy raised his hand and said, I'm from Colorado and I know that area and they actually need those no gun signs at that theater. And the first thing that came to my head when he said, this guy's a moron.
Yeah, some people either cannot or refuse to be reasoned with. But my sense of this, just sort of dealing with people is that most sort of people of goodwill are willing to hear you out. There are some, this is one of those hot button issues, unfortunately, that really raises people's hackles on either side. People on our side get emotional and get, upset. People on the other side get emotional and get upset. I've had friends, who can't be reasoned with. But as as people who want to live good, honest, productive, free lives, I think we have to still believe and live as if most people are people of goodwill who want to live good lives and can be talked with. One of the problems I think that we face today is that nobody talks to each other anymore. And things are so polarized. And, a lot of it has to do with social media, a lot of it has to do with traditional media. And there's an incentive to, the state is the beneficiary of all this stuff, right? The state is the beneficiary of the polarization, of the fact that people have a much harder time talking to each other anymore. It's very important that we talk to each other. I know people who who are Republicans or conservatives who will not talk to or be friends with Democrats/liberals, and vice versa, Democrats and liberals who will not be friends with Republicans or talk to Republicans or conservatives. It's completely the wrong way to live life.
It's ridiculous.
You've got to talk to your neighbors. You've got to talk to your family members. You've got to talk to your neighbors. You have to assume that your friend, neighbor, or cousin or uncle is a person of goodwill who wants to just live a good life with their families and their communities. Because if we lose that, we're done. Society cannot exist if we can't just talk to each other.
But I think it's reasonable that if you have this conversation with somebody and they're not willing to accept reason and they're talking past you, that maybe you don't talk about that particular topic anymore. Maybe you like the same music and you like the same movies and everything like that. That's okay. And to this guy's credit, when John Lott responded that, hey, I understand what you're saying, but we just talked about how he specifically chose this place because of the no gun sign and nobody had the means to protect themselves. And he obviously didn't listen to the no gun sign when he went in and massacred all these people. It seemed like he understood Dr. Lott's point. And incidentally, I think it was 18 months later, Dr. Lott was sitting in a courtroom with me in Harrisburg as an expert witness on a gun case. So that was pretty cool.
Yeah, he's great. He's a really good guy.
I want to go back to the sensitive places. You were talking about how Governor Murphy signed King Philip is how he's referred to, right? I don't want to get us into trouble, but he signed the bill in the library as one of the sensitive places. I keep picturing in my head you sitting there getting ready to file and Scott Bach with binoculars and a walkie-talkie letting you know when it's going to be signed so you can file. But you talk to people on the anti-gun side or people who are simply unfamiliar because of the culture in places like New York and New Jersey. The first thing that comes to their mind might be, why would you bring a gun to the library? Like, who brings a gun to the library? And they're not understanding that for gun owners, we carry everywhere.
Right.
It's not like we pick and choose or, oh, I'm going to the library, let me bring my gun. It's like keys, wallet, phone, gun.
Right.
And they don't seem to understand that, do they?
For people who don't live the lifestyle of firearms, it's not intuitive. They don't understand that it's exactly as you said, keys, wallet, gun, right? It's something that is useful and important everywhere you go, for all the same reasons. For the same reason you bring it to the supermarket, you bring it to the library. Murder happens everywhere.
Bad guys don't make appointments.
They don't make appointments, and they don't say, I don't really want to kill somebody in the library. I'd rather commit murder in a movie theater. It's like, well, that's ridiculous. They commit murder wherever they can commit murder. And as we know from these horrific incidents, one of the important things to these people is notoriety and publicity, right? So they want to cause the most damage, the most carnage, the most bloodshed, the most dead bodies they possibly can. That's what it's about to them, So it's like, I won't do it in the library. The only reason they wouldn't go to a library is that they didn't think there were enough people there to murder, But otherwise, the library is just as a legitimate target as anyone else for a murderer, anywhere else for a murderer. So again, you carry where you carry, your keys, wallet, your pistol.
This leads me to something else because Guy Smith is another person who does research on these kinds of issues, and he's talking about how magazine capacity makes no difference with these mass killings, and they're really restricted to cattle pen type scenarios where people are confined in a closed space. because they want that count to be as high as possible, and that's what their sole concern is. And magazine capacity restrictions are interesting because they really do put law-abiding citizens at a complete disadvantage.
Right.
Only the bad guys have the higher capacity magazines if the good guys follow the laws. This is something that you are litigating here in New Jersey, isn't that true?
Yeah, so we have one of our big cases is our magazine challenge. It's called Association of New Jersey Rifle and Pistol Clubs versus Platkin. And it's currently on appeal at the Court of Appeals for the Third Circuit. That case, actually, we started that case back in 2018. That's been actually going for a while. That's been up and down several times. We went up to the Third Circuit. We went back down again after the preliminary injunction was decided, back up again on a final judgment. Then we filed our petition with the U.S. Supreme Court. That case actually is one of the cases that got sent back down to the lower courts after Bruin. So what's interesting, this is a little bit inside baseball, but it's actually interesting to understand the logistics of how this stuff works. When the Supreme, one of the things that happens when the Supreme Court is deciding a case on a particular subject matter, you will sometimes have other cases that might be presented to the court on a petition. Let me remind your audience, the Supreme Court has a discretionary docket. They don't have to hear cases, with small exceptions. They basically don't have to hear cases they don't want to hear. They pick and choose cases that they hear. And the criteria, based on various criteria that's both in the rules, but also as a matter of tradition and law. So when you want the Supreme Court to hear your case, you file what's called a petition for certiorari. And that's simply a request to the Supreme Court to hear the case. Most petitions are denied. Small handful of petitions are granted, and then once they grant that petition, it means they're going to hear the case. The parties will file their briefs. It'll be scheduled for oral argument. It'll be argued, and then it'll be decided. So during the Bruin case, after the cert, what's called the cert petition was granted, we now knew that was going to be heard. And it's a process. There's briefing, get on the argument calendar, there's a decision. So it takes some considerable time, although it all happens during the course of the term. Well, it doesn't all happen, but it gets decided by the end of the term. So other cases can also be presented to the court on a petition while the Bruin case is pending. And as it turned out, there were several Second Amendment cases that had petitions with the court at the time the Bruin case was pending. One of them was our magazine case. Another case was a case out of Maryland, a so-called assault weapon case out of Maryland. It was called Bianchi, later became Snope. But anyway, there were a few cases. And what ended up happening was, and this is very common, when the court decides an important case on a particular subject matter, it is very common for other petitions on related subject matters, they get what's called GVR'd. The petitions get granted, that's the G, and then the decision below gets vacated immediately, that's the V, and remanded, that's the R. So they grant, vacate, remand in one swell foop, as they say, and they send it right back down. And the reason is because we've now clarified the law, or we've changed the law, or we've established new law. The court has done something that matters on the subject matter. We're going to take these petitions in front of us, we're going to send the cases back down to the lower courts, and we're going to direct the courts to decide them again in light of our new ruling. And it may change the outcome, it may not change the outcome, you don't know, but what the court is basically saying is, okay, we have either new law, different law, clarified law, or something, do this over, and now consider this new case. So we are our magazine case is one of the cases that got GVR'd. And so we went back down to the lower courts to do it again. Now, the other thing that happened was after Bruin, we also filed a so-called assault weapon case in New Jersey. FPC also filed an assault weapon case in New Jersey. So all three cases ended up getting consolidated procedurally. Again, the state made their motion. The court granted it. So actually, it's three cases. It's ANGRPC versus Platkin. That's our magazine case. We have a case called Ellman versus Platkin, which is our so-called assault weapon case. And then there's the third case called Cheeseman versus Platkin, which is also an assault weapon challenge being brought by FPC. So as I said, our cases are ANGRPC and NRA cases. And again, when you have these cases all being briefed and argued together, you can sometimes benefit from different ways of thinking about the legal rule. So you may get arguments The other guys may argue something a little bit different than you. And what you may end up with is the judge has more than one choice as to the legal theory by which you win, right? Because if the judge accepts our theory of the case, we win. If the judge accepts their theory of the case, we win, right? So in a sense, there can be benefit from having multiple sets of plaintiffs litigating the same issue in front of the same judge. You get sort of a menu of ways to win. So that can actually be very beneficial sometimes.
In general, what you do with your litigation is very different than litigating for the individual client. So
Right.
guys like Evan and I were typically dealing with individuals who are maybe facing prosecution or need to restore their rights. And we get very wrapped up in that particular result because it means the world to that particular client. With what you're doing with multiple lawsuits in conjunction with lawsuits in other jurisdictions, you really have to play the long game, don't you?
Correct. And that's exactly, I say this all the time. I think people who listen to me on various podcasts or shows hear me say this over and over again. It must be tiring. It's a marathon, not a sprint. Individual cases matter, but it's the long game that really matters because there are magazine cases all over the country, not just ours. In fact, there's actually one out of California called Duncan, which is actually, I think they're going to file their cert petition like next week, I think, or maybe they filed it last week. They're filing it imminently. If they win on their magazine case, we all win, right? So sure, it would be great if we had won our magazine case with the district judge. We didn't. We lost, and we're appealing that to the Court of Appeals for the Third Circuit. But if the Duncan plaintiffs win at the Supreme Court, if the Supreme Court grants their petition and decides in their favor, we all win. And you're right, it's very different than representing an individual client on an individual claim on an individual set of facts. That case matters to that client for that set of facts. Whether you're a personal injury lawyer and it's a dog bite case, or you get by a car or whatever, or whether it's a contract claim, a business dispute. I spent many years as a commercial litigator doing business disputes. I still do that, but the civil rights stuff is so much more of my practice now. I really very heavily focused on that. But that client cares about that contract, that set of damages. And the rest of, you might make law, but usually you're not making law. In the case of the civil rights cases, and particularly the Second Amendment cases, you are making law or you're trying to make law. And because of that, the convergence of these lawsuits from all over the country, as they all make their way, hopefully, to the Supreme Court, that's the long game. It doesn't matter. I'd love to be the lawyer litigating the magazine victory at the Supreme Court. But if I'm not, but someone else is, that's just as good because it's not about ego, right? We all, look, we're humans. We all have ego. We all want to be the guy. But ultimately, it's not about the ego. It's about people's constitutional rights and fundamental rights. If the Duncan case is the one that wins us the issue on magazines, everybody in New Jersey benefits from that.
Well, it's sort of like how Mr. Rogers and everybody in New Jersey benefited from Bruin, right?
Correct. So as a lot of people don't know, that Bruin was one of 3 companion cases. It was actually part of a broader strategy to get a carry case to the Supreme Court. The Supreme Court having changed composition over the years. And so there were a lot of carry cases decided shortly after Heller that lost. In the Third Circuit, it was Drake. In the Second Circuit, which is New York and Connecticut, et cetera, and it was called Kachalski. There were every unfavorable jurisdiction had a carry case early on, and most of them lost. Not all of them, but most of them lost.
And the Supreme Court wasn't hearing them.
Right.
Like Baruda from California was the one where Clarence Thomas wrote the scathing dissent.
Exactly. So between 2010, when the McDonald decision was decided, and 2022, when Bruin was decided, there were no Second Amendment cases. There was one exception. There was the New York City case, but that ended up getting mooted. New York City had this ridiculous travel restriction where you couldn't leave the city with your firearm. I mean, it was illegal. If you lived in Manhattan, for example, and you wanted to go to Anthony Calandro's range, gun for hire, you couldn't do it. It was illegal to take your gun out of the city. It's crazy. That ended up at the Supreme Court. New York City ended up changing their rules strategically, and the New York State legislature actually cemented that in place with a statute that kind of prevented them from going back on that rule because there's a procedural issue, as you know, with mootness. So the case ended up getting mooted, and it didn't go anywhere. But other than that, then nothing happened. They wouldn't take any Second Amendment cases for years. And as you correctly noted, Justice Thomas would routinely dissent from the denial of cert. So when the court would deny the cert petition, the certiorari petition, it was very common in a Second Amendment case, it was very common for Justice Thomas to write an opinion saying, what is wrong with you people? We've decided, I'm trying to remember which case this was, where he said this, but it actually might have been in Rogers.
When he was talking about how many cases.
How many First Amendment cases?
That was the Peruta case.
It was Peruta, right,
Yeah.
out of California. That's right. When cert was denied in Peruta, Justice Thomas wrote, we've taken however many First Amendment cases, we've taken no Second Amendment
Called
cases.
the disfavored right.
Yeah, exactly. And it's very frustrating. So things had evolved on the court, and so it was decided that we'd take another shot. And so 3 companion cases were commenced at the same time. Bruin was called Beach at the time, was the New York. So it was 3 jurisdictions, New York, New Jersey, and Maryland. Beach was the New York case. My case was New Jersey, was Rogers versus Graywall at the time. And there was a case out of Maryland called Malpaso. And if you compare the complaints, they're almost exactly the same. They're drafted the same way on purpose. The idea, and for your audience members who aren't familiar with the logistics of how we do this, civil rights cases are generally different than other cases in that they are created to tee up the important legal issue so that courts can hear them and decide them. Most cases arise spontaneously out of events. Someone got hit by a car, someone breached a business contract, whatever, right? And so there's a series of events that result in a dispute between parties. Civil rights cases are the other way around. You have an important legal issue. You have a statute or some regulatory provision that violates people's basic rights. You need to challenge that law. And in order to do that, you need to have a case that is appropriate to be heard by a court, because courts can't just hear any dispute. You need to satisfy certain rules, like, for example, standing, as you're aware of. And standing simply means you have the kind of injury that entitles you to complain about that injury. You've been injured by this law, so now that entitles you to go into court and say, Judge, I am injured by this law. My constitutional rights are being impaired. I have a right for the court to examine this law and tell me that this law cannot be enforced and is unconstitutional. And that's how these civil rights cases are created, because, you can imagine that you can challenge a criminal law by getting arrested, but who wants to get arrested? More likely what happens is people simply forego the exercise of their constitutional rights out of fear of arrest. But that's exactly what gives you standing to be a plaintiff in a civil rights action under Section 1983. You get to go to court and say, I have a right to do X. I would do that, but I'm afraid of being arrested and prosecuted under this law, which is unconstitutional. Therefore, I refrain from exercising my constitutional right because of this law. That essentially gives you standing to go into court and say, Judge, I want a ruling on this because I have a right to carry under the Constitution, but I can't because they're going to throw me in jail. And that is the difference between these kinds of cases and sort of your typical litigation that people, lawsuit that people are familiar with. And so because of that, you build these cases from scratch. And so in the case of Bruin, there were 3 companion cases, from the 3 of the worst jurisdictions, New York, New Jersey, and Pennsylvania. And the idea was that hopefully one of these cases gets to the finish line. Interestingly, our case, we moved our case very quickly. We got through the district court in 6 weeks. We got through the Court of Appeals in, I think, 3 months. We filed our petition with the Supreme Court in less than a year from filing of the case, which is unheard of. One of the reasons we were able to do that is because there was already a precedent from the Court of Appeals for the Third Circuit that says you have no constitutional right to carry. And so all we really had to do was tell the district judge, look, Judge, you have to rule against us because the Third Circuit says you have to rule against us. So can you do us a favor and just send us along to the next court, because there's nothing you can do for us. We're right as a matter of constitutional law, but you literally can't help us because you are bound by what the appellate court says you must do in this case. So please do it now so that we can move on to the Court of Appeals for the Third Circuit and move the case along. And that's what he did. 6 weeks, he ruled against us and we moved on. Then at the Third Circuit, we basically made the same argument. We said to the court, your bet, because the way the courts of appeals in the federal system work is that the first, typically it's 3-judge panels, as you know. The first 3-judge panel to decide a new issue basically sets the law for that circuit. So in the Drake case, the law for the circuit had been set by the 3-judge panel in the Drake case, which was no constitutional right to carry. So no matter what, any other 3-judge panel within the Court of Appeals for the Third Circuit hearing a carry appeal were bound by that. They're not allowed to make their own independent decision. Now, what you could do is you could seek review by what's called the en banc court. En banc is just a fancy way of saying the whole court. Now, we're not going to talk about the Ninth Circuit because they don't do the whole court. They have like 40-something judges there. So when they do en banc, they actually just take a subset of judges. But every other circuit, it's the whole court, or at least it's all of the active judges, because you also have senior judges that are kind of partially retired. So the en banc panel, all of the judges can overrule what a 3-judge panel has done, but no 3-judge panel can do it. So we basically said it's exactly the same thing to our panel. We said, look, you're bound by Drake. You can't undo Drake. So we're just asking you to rule quickly. If you can just rule quickly, we'll head off to the Supreme Court and do our thing. And we made a motion for what's called a summary disposition, and they did that. In 3 months, they had us out of there, and we filed our motion with the Supreme Court. Now, the rest of the story is, so our petition, this is the Rogers case. Our petition was pending before the Supreme Court while the New York City case that I talked about earlier was pending. So, and there were a whole bunch of petitions that were building up. There were actually 10 Second Amendment type petitions that the court was holding on to while they were deciding the New York City case. So when the New York City case got mooted, I'm thinking to myself, great. So they didn't decide a Second Amendment case, so we've got one right here ready to go. So yay, right? Cert granted, cert denied. All 10 cases got denied. And we're like slapping our foreheads. What the heck happened? They didn't take any of the cases. And we were so disappointed, of course, because we're thinking like, we're there, yay. Cert denied. What happens next? And what's ironic is that the New York case was bogged down in the district court. We got out of the district court in 6 weeks. The judge wasn't ruling. And you can't make a judge rule. The judge rules whenever the judge rules. So if you're bogged down, you're bogged down. You can't say to the judge, hey, judge, hurry up. So we're like looking at the New York case like, those guys are stuck in the mud. Here we go zooming through the courts, right? We're like so proud of ourselves. Well, when we get denied, we're thinking, what in the world happened? The next thing that happens is, as people may remember the history, Justice Ginsburg passes. Justice Barrett is seated on the court. Bruin then gets to the court. It went through a couple of name changes. It started as Beach, became Cordelette, and then by the time the decision on the petition came, it was Bruin, because apparently New York goes through superintendents of state police like water, like people change their underwear like this. Every year there's like a new one, So the names keep changing. Cert granted, and it's all about Bruin suddenly. So had the timing been different, we might all be talking about the Rogers case. But importantly, and look, egos aside, whatever, would I have loved to have been the lawyer, sitting at counsel table at the Supreme Court arguing over right to care? Of course I would, as would my clients have been. But ultimately, Bruin was a tremendously valuable decision vindicating the fundamental constitutional right to keep and bear arms. It didn't just vindicate the right to carry, which was very important, but it also corrected or sought to correct those years of abuse by the lower courts as to what the correct rules are under the Second Amendment. Because, case after case had been losing for years because the courts had adopted a very unfavorable way of understanding the Second Amendment, totally contrary to what Heller and McDonald ruled. And this was one of the very frustrating things that Justice Thomas was concerned about, based on what he was writing in his dissenting opinions, is that the lower courts were just being abusive. They were just essentially ignoring the message of Heller and upholding one law after the next, and not really taking the Second Amendment seriously. So finally, what Bruin did was, and when you read, I encourage people, whenever I talk about these things, I encourage people to read the opinions, because unlike a lot of legal opinions, these are really interesting and very illustrative. They talk about history, they talk about the concepts, they talk about the constitutional principles. So I always tell people they should read Heller. and McDonald, but they should also read Bruin, because when you read Bruin, you can hear in Justice Thomas's approach that he's doing whatever he could possibly do to prevent the lower courts from screwing around. Because of the years of abuse from the lower courts, it's like, look, we really mean this, As we know, as lawyers, there's only so much a court can do, particularly even the Supreme Court, to rein in the lower courts. You do the best you can. You try to set certain rules and procedures. But of course, no court can account for every scenario. And the Supreme Court has explicitly said on many occasions, look, we're not resolving every aspect of this particular concept or the Second Amendment in the case of Heller. But you can read, as you read Bruin, you can see that he's writing it in a way that he's thought about all the different ways the lower courts could screw around with the Second Amendment. He's trying to foreclose as many as possible. It's a great opinion in that regard. It's fascinating to read, to watch that unfolding as you read the pages, of the stuff. And so that's Bruin. And we all benefited from Bruin. And the fact that our case wasn't the one, yeah, sure, it's aggravating, but ultimately it's the advancement of the constitutional principle that really matters. And that's why it's the long game. We had 3 cases heading in the same direction. One of them hit, and hit big. And that was the plan. And that's why the fact that there are lots of cases on these various issues, not just magazines, not just so-called assault firearms, not just carry killer laws, but all sorts of issues. Like, there are 5 states with these carry killer laws. So you've got the New York cases, you've got the New Jersey cases, you've got the California cases. Maryland is actually heading, is actually in the lead here as far as heading towards the Supreme Court, because Maryland, they're on final judgment. They actually I believe they just argued their case in front of the Fourth Circuit, which is the Federal Court of Appeals that includes Maryland and Virginia and some of those states there, North Carolina. So that case actually could end up at the Supreme Court well before ours. And again, if they win, we win. And that's the long game concept.
With the magazine capacity restrictions and assault weapons ban, as they call it, the litigation that you're involved in might sound foreign to some people in certain states simply because in places like Pennsylvania, we don't have such a thing.
Right.
And places like Oklahoma, they don't have such a thing. So could you explain a little bit about what the issue is and, the legal theory that's being used in order to try to get them struck down?
And that's true about a lot of these laws. I mean, magazines, assault weapons, all those things. People think we're crazy, and we are. I mean, it's a little nuts, the kinds of laws we have. I mean, we still can't pump our own gas in New Jersey. It's a lunacy.
You got to be a trained professional,
right? Because
I always sort of tied the two together. The fact that New Jersey didn't allow civilian carry, essentially. And they said they won't even let their citizens pump their own gas. They think that they're not responsible enough to do so without some kind of specialized training.
It comes down to the fact, I say this all the time, and it's aggravating and insulting at the same time. New Jersey treats the citizens of New Jersey like we're third graders. That we're treated like children. And it's so insulting. New Jersey has, and New York is similar, and California is similar. We are treated like we're morons and all irresponsible people. Because what do? They make laws that are broadly applicable to everybody, regardless of your level of responsibility. Because a tiny minority of people could use a magazine in excess of 10 rounds to commit murder. No one gets to have magazines in excess of 10 rounds. And this is why we can't have nice things. Even though the overwhelming majority of people are responsible and law-abiding, nobody can have these things because some random people could use it to commit murder. And it's basically saying you people can't be trusted, and you're like children. It's maddening that there are a whole bunch of states that treat their citizens like this.
The fact that so many people use them lawfully really ties into the constitutional challenge, doesn't it?
Yeah, there's actually a great, a really interesting issue in the magazine cases. The states with the magazine that have the magazine challenges, there's an expert that they use in a lot of these cases, including in our case, where and for your audience, an expert meaning an expert witness. When you litigate a lawsuit, you present 2 types of evidence. You present factual evidence, which is the light was red, the light was green. the contract said 10,000, no, the contract said 5,000, right? But then you can also offer opinion evidence from experts who, if they meet a certain threshold under the law, because not everybody can just offer an opinion. If you meet a certain threshold, the court will allow this person to testify as an expert on the subject. So one of the experts that a lot of these states have tried to introduce into the magazine cases, including New Jersey, is an expert that says the average self-defense scenario involves 2 rounds. 2 rounds fired in self-defense. So why do you need a magazine in excess of 10 rounds? They seriously make this argument. And the lunacy of that is, let's assume that's true. I don't believe it is true, but let's assume it's true that the average of self-defense scenarios with a firearm involve the discharge, where a firearm is in fact discharged. Because as we know, the vast majority of defensive gun uses, DGUs as they call them, don't even involve squeezing the trigger.
Right.
We know that from Gary Kleck. We know that from a variety of sources. But even so, let's say it's true that in those situations where someone is actually squeezing the trigger in self-defense, let's say it is true that the average scenario is the discharge of 2 rounds. Okay, that means that there are some people who discharge fewer than 2 rounds and some people who discharge more than 2 rounds. So the idea that the average number of rounds used in self-defense is 2, and so the message to the people who actually do require more than 10 rounds to exercise in self-defense, sorry, but you're going to have to die because we're holding you to the standard of the average defender, not your actual situation where you do need more than 10 rounds to defend yourself. It's lunacy, But that's some of the stuff that we're up against in these cases because the merits are so squarely against these oppressive states like New Jersey, New York, California, Maryland, et cetera, that they need to resort to that kind of sophistry to try to convince a judge who doesn't understand the issue because it isn't familiar with it. Judges are generally pretty smart, but if you present something to them that's foreign and you can make something seem sound, they can be convinced of these things. You have to push back on it. But when you have some so-called expert saying, oh, yes, and in our research we have found that the average self-defense scenario is the discharge of 2 rounds in self-defense, and therefore there's no reason why they would need a magazine in excess of 10 rounds, like that could seem plausible to someone who's not familiar with what's actually happening in the world in the exercise of lawful self-defense, and so that's some of the kind of stuff we're up against in these magazine cases.
And lawful common use at the time, Bernie Sanders, I believe it was, even said on some show that 99.9% of people who own an AR or modern sporting rifle aren't going to use it to do anything bad, which I think works in our favor.
Right.
Which brings me to another one of your cases that I want to talk about. When he was running in the primary before the 2016 presidential election, somebody asked him about whether laws should change, opening up the ability to sue firearms manufacturers. And his answer was a very firm no, because that would effectively end the manufacture of firearms in the United States, and I'm not willing to do that, which is what he said. You have another case that deals with that issue, doesn't it?
Right. So I represent the National Shooting Sports Foundation, NSSF, which is the trade association for the firearms industry. And we have a case against the state of New Jersey right now, which involves a recently passed, within the last couple of years, a recently passed New Jersey law, which creates these sort of very vague and generalized sort of code of conduct type of requirements, reasonable controls. They use the language reasonable controls. What it does is, because up until this law that was passed a few years ago, the firearms industry in New Jersey knew what was expected of them. Why? Because there's lots of laws, but the laws are usually pretty specific. You must do this if you want to sell that. You must go through this process if you want to sell this other thing. And the industry, the dealers would say, okay, I have to do these things. Whether or not those requirements are lawful or constitutional, the industry knew what was expected of them. They did those things and they stayed out of trouble. What this new law does is it creates a much more generalized, vague expectation so that it's actually difficult to know what's expected. So, for example, and in some cases, it contradicts the specific requirements. For example, on ammunition, right? There are specific rules on what you have to do to sell ammunition, and there are different rules for handgun ammunition versus rifle ammunition. There's New Jersey recently created an ammunition registry, an electronic registry, but again, the registry says generally what you're supposed to do, and so the dealers, do their best to try to figure it out and comply with it. The new law, they actually sued a dealer recently. They have several lawsuits, but they sued a dealer for not requiring certain identification for the sale of rifle ammunition, even though there's no requirement for the sale of rifle ammunition in the laws in that way. So now dealers are saying, well, wait a minute. I've been following these laws. I know how to sell handgun ammunition. I know how to sell rifle ammunition. I know what I have to look for. How do I know what these sort of reasonable controls are? How do I know what this sort of generalized expectation is? And so the lawsuit challenges that law. Now, this is kind of interesting because NSSF brought this lawsuit several years ago and got a favorable decision from the district judge. It went to the Court of Appeals for the Third Circuit, and what the Third Circuit, they reversed that decision. What they said was the lawsuit is premature. New Jersey hasn't started enforcing the law yet, and so while it may very well be the case that New Jersey is going to abuse the rights of dealers in how they enforce it, since they haven't done it yet, it's too early to know. You're speculating that they could do this, but they haven't done it yet. So the Third Circuit says we're going to require that this be dismissed until some other things happen where there's a better basis to know whether the Constitution is actually being violated or not. Well, what happens, of course? New Jersey immediately starts bringing abusive lawsuits. As soon as they win that case, they immediately start suing people. And so, of course, we bring the lawsuit again. So we're back. And, of course, we knew that they were going to abuse the statute. But since they hadn't abused it yet, the court said, look, you got to wait. So, of course, we brought it back, and now we're back in litigation. But the history, one of the important theories of the case is under a statute called the Protection of Lawful Commerce in Arms Act, the PLCAA, or PLCAA, as people like to call it. What PLCAA is that it's a statute that Congress passed to protect the firearms industry from abusive, destructive litigation. What happened was, back in the 2000s, the anti-gun folks got this idea. What they realized is they couldn't get laws passed that they wanted because people were not willing to support them. But what they realized they could do is they could sue the firearms companies out of existence, because you don't have to win a lawsuit necessarily. All you have to do is impose crushing, punitive attorney's fees on a company that can't afford it. And unlike big tobacco, big oil, big pharma that involve billion-dollar companies, gun companies are not that big. Gun companies, people have this idea, big bad company, whatever. People who don't like guns think about it as big bad gun manufacturer. These are not big companies by comparison. They can't withstand the onslaught of punishing litigation. And so the anti-gun people got this idea, we'll just sue them out of existence and we'll destroy the gun industry that way. And they were well on their way to do that. There were a ton of lawsuits directed at these manufacturers, and it was impossible for them, and they would get dismissed on their merits, but only after spending a fortune in litigation costs. So what they realized is okay, they'll get dismissed. We'll just keep bringing them and bringing them and bringing them and bringing them until finally these manufacturers are gone because they simply go bankrupt. And so PLCAA was passed by Congress to protect the gun industry from these abusive lawsuits. There's no other, imagine, right, suing Ford because of an auto accident or because, that has nothing to do with the car, or some guy plows into a crowd to, there's some rally or protest or whatever. Some guy doesn't like the issue that crowd is protesting about, so he takes his Ford and he plows into the crowd and kills people. It's like suing Ford over that. Ford has nothing to do with that. And generally speaking, in the law, a manufacturer is not generally responsible for the misuse of its products, except those were the kinds of lawsuits that were being brought against the gun industry. They knew they weren't going to win, but it didn't matter to them because they could destroy the manufacturers purely by the cost associated with defending themselves. And so that's what PLCAA is about. And that's, people tend to mischaracterize it. People, anti-gun folks will say, well, the gun industry is the only industry that has protection from, you can't sue a gun manufacturer. That's not true. You can sue a gun manufacturer under traditional principles of liability, just like a car manufacturer, a drug manufacturer, any of these things. What you can't do is bring these improper, abusive lawsuits that are designed specifically to destroy the companies through litigation.
Well, we really appreciate everything you've done over the years standing up for the Second Amendment, and the people in New Jersey owe you a great debt of gratitude for everything that you've done. Any parting words for our audience, Dan?
All I can really say is people have to, I'm going to go back to it's a marathon, not a sprint. People have to know that we're going to win. It's 3 steps forward, 2 steps back. There are losses along the way. It's very frustrating, but people have to remain confident, steadfast, and dedicated. It's the only way free people remain free. You have to fight. You have to be dedicated to the vindication of your fundamental rights, and that's how people remain a free people.
Is it a thankless job sometimes?
Sometimes it's thankful. People do appreciate the stuff that we do, but other people relentlessly complain. It's like, why didn't we win this? Why aren't you bringing these 10 cases that are on issues that I like? Well, there are important strategic and tactical reasons why we bring certain cases when we bring them.
Why is this case taking so long?
Why is this case taking so long? And some of them are taking an absurdly long time.
It's yes, we know. We deal with litigation all the time.
Yeah.
It takes long.
But you have to remain steadfast. People have to just remain steadfast, continue to fight, continue to push, because that's the only way you vindicate your rights. They're always going to come after your rights. They will never stop trying to take away your rights. Therefore, you must continue to fight and remain steadfast.
Are you familiar with the Teddy Roosevelt speech, The Man in the Arena?
I'm not actually.
Okay. We'll have to familiarize you with The Man in the Arena. All of our listeners who are paying attention, go check out that speech. Evan and I each have a display in our office with the Man in the Arena speech. I'll have one coming your way. I really appreciate you joining us today.
Thanks so much, Mike. This was a lot of fun. I really enjoyed it. Thank you.
The same here. We miss you, Ellie. Daddy loves you. Thanks for tuning into the Mike G and the Garbage Gang podcast. If you want to be a proud member of the Garbage Gang, we need you to like this video, subscribe to our YouTube channel, check out one of the recommended videos, and comment. Tell us what you think. We love having you as a member of the Garbage Gang. We'll see you next time.